Hey guys. We've had a letter to the court in Texas from Judge Wallace. Well worth a read. um, so we're gonna look into this now. Before I quickly start, I'm not going to be. I've been asked if I will be doing any videos on the situation with Perez Hilton. I won't be. He deserves his privacy. And other people have commented on the situation anyway. I send a lot of love, all the best to Perez, to his children, his mother, his family, friends. It was a heartbreaking thing to read when I woke up this morning. And he has always been very kind to me. So I really do hope that he's getting all the help that he needs and he makes a full recovery soon and is back to the lovely, bubbly Perez Hilton that we all know and love. I've got an update on the case to Celeste Smith against Steve Sauritz and the Wayfarer Foundation case, which I will probably do tomorrow now. But I want to focus on this one. So this is, just to remind everyone, this is the Jed Wallace case in Texas where Blake Lively successfully got herself dismissed and then requested nearly $1 million in attorney's fees and costs. That is still going on. It's obviously also awaiting Blake Lively's response to Jed Wallace's appeal, which is due a bit later on this month. It might be next week or the week after. But this is regarding the the fee request from Blake Lively, which is completely unreasonable, but nowhere near as unreasonable as the one against Wayfarer. Okay, so plaintiff's motion for order requiring Blake Lively to give her deposition. Plaintiffs Jed Wallace and Street Relations submit this motion requesting that Blake Lively be ordered to give her deposition solely about her claim for attorney's fees and damages. So this is not about anything else, not regarding the underlying matter that brought all of this to the court. This is purely over her request for those fees. Okay, so executive summary. Not satisfied with dismissal of the Wallace party's claims solely on personal jurisdiction grounds, Lively goes on the offensive seeking fees and damages of around $1 million, not under Texas or New York law, but in reliance on an anti-SLAPP-like procedural statute found in California Civil Code Section 47.1. Relying on a case of first impression decided in June of 2026, Lively argues that in her notice of supplemental authority that to avoid liability, respondents must negate her claimed privilege with admissible evidence of her malice. But, and this is the crux of this dispute, Lively says she does not have to give her deposition on that issue, even though she is presumably the best and perhaps the only witness who can testify on whether she was malicious when she communicated her allegations of sexual harassment against respondents. Lunch should not be free when Lively seeks around $1 million from respondents and attempts to reverse the burden of both coming forward with evidence and proving her malice with that evidence, which, if shown, would defeat the claim privilege and its remedies. Introduction. Lively, a party, refused to and did not appear for her noticed August 4th, 2026 deposition. Okay, so she was supposed to have a deposition yesterday and did not bother to show up. She did not appear for her noticed August 4th, 2026 deposition regarding her post-dismissal substantive motion for nearly $1 million in attorney's fees plus costs and treble damages, including punitive damages. Her counsel claimed the notice had no legal basis and was null and void, but made no effort to advance those arguments before the court prior to the deposition as the rules require. Respondents asked the court to order Lively to appear for her deposition at an agreed time and place on a not later than date set by the court and to award them their attorney's fees. This case all started when Lively filed a complaint with the California Civil Rights Division on December 20th, 2024 against Wallace and Street, even though neither Lively nor respondents reside in California, nor is it the state where the alleged harassment occurred. Claiming she was harassed because of complainant's sex, gender, sexual harassment, hostile environment, despite never having met or interacted with them. The case was closed the same day and it was filed. The case was closed the same day it was filed and a right to sue letter was issued. Also that day, Lively provided a copy of the CRD complaint to the media, specifically the New York Times, whose reporter contacted Wallace within hours of the filing with an urgent request for comment because the reporter wrote that she had learned that Ms. Lively filed a legal complaint against you alleging sexual harassment among other claims. The subsequent publication of the false claims of sexual harassment and other misconduct caused respondents to file this lawsuit for defamation in their home, Texas. Lively filed a motion to dismiss, and Judge Ezra agreed that the court did not have personal jurisdiction over her, a New York resident, and dismissed the case without prejudice and without deciding on any other basis for dismissal. Over 5 months after that ruling, which was appealed and is still pending, Lively moved pursuant to Federal Rule of Civil Procedure 54 and under, she says, a substantive California statute for attorney's fees of approximately $800,000, not including the fees incurred in connection with preparing and litigating the fee motion, to which Lively is also entitled, costs and treble damages for any harm caused by this defamation in addition to punitive damages. On June 12, 2026, she filed a supplemental authority attaching a ruling in a case from the United States District Court for the Southern District of New York, where Lively sued Justin Baldoni and others, including Wallace and Street, who were dismissed before the ruling. Lively's counsel argued that the ruling is relevant to numerous issues raised by the parties, specifically her argument that respondents bear the burden to prove Lively's malice, and even sufficiently alleged malice is insufficient to avoid fee shifting. That's true. She did make that. She made that argument in New York against Wayfarer, that it was for them to prove her malice. With that in mind, that is what Jed Wallace is attempting to do by deposing her, and she's just not turned up. She's like, nah. Although respondents disagreed with the applicability of the ruling and Lively's reading of it, given the New York decision and the amount of fees, costs, and damages she is seeking, respondents requested Lively's deposition. Counsel met and conferred both by phone and email, ultimately resulting in, when negotiations proved unsuccessful, respondents serve a notice of deposition for Miss Lively to appear for deposition in New York, her home state, on August 4th, 2026. Upon receipt, her lawyer claimed the notice was of no legal basis and null and void, but made no effort to seek a protective order during the approximate 3-week period between the date the notice was served, July 13th, and the scheduled deposition, August 4th. Last week, Lively's lawyer confirmed that his client would not appear for the notice deposition and implied that he would seek sanctions if respondents pursued the deposition or even mentioned publicly that she had refused to appear on August 4th. They can't do that. He put respondents on notice that if they pursued this frivolous discovery, Miss Lively would be represented by all of the 7 attorneys on the email exchange at their hourly rates charged by Miss Lively's attorneys in the New York case, and she would seek to recover all of their fees for preventing her deposition. Wow. He also indicated that if respondents sought to depose Lively, she would, in the alternative, request document discovery on your clients, their depositions, and 5 additional depositions, including the lawyer for Baldoni and others in the New York case. And she would seek attorney's fees and costs for all that discovery. Oh, she sounds delightful. Moving ahead, despite the threats, the monetary relief Lively is seeking and her unique knowledge of her malice, or she would say lack of it, entitles respondents to this discovery. She is, after all, the one who invoked Rule 54D, seeking fees and damages under California Civil Code Section 47.1. And advancing the, we say, novel argument that respondents have to negate her claimed privilege with admissible evidence of her malice. No discovery has occurred in this case at all because Lively has blocked it at every turn. Her counsel refused to participate in Rule 26F conference, forcing Wallace and Street to file a motion to compel conferral, which Lively opposed. Having blocked all discovery, Lively now argues that this absence of malice evidence bars respondents from opposing her fee motion. The Lively motion should be denied on the merits, as respondents have demonstrated in their response. But even if the court concludes that Section 47.1 could theoretically apply, the respondents are entitled to, pursuant to the fact-finding contemplated by Rule 54D, limited discovery, specifically Lively's deposition to establish Lively's malice, precluding application of the California procedural device. So it sounds like he wants a limited deposition, which is just like, tell me more about the reasons why you chose to wait and, till months after to file a CRD complaint. And tell me, why did you hand it to the New York Times before, we got a copy of it? Etc. That's what it's going to be. Okay, the facts. In addition to the facts outlined above, we refer the court to respondents' amended complaint and plaintiff's response to defendant's motion for attorney's costs and attorney's fees. We incorporate those pleadings by reference. So I'm not going to go through the long-winded arguments here, but the court has broad discretion in determining scope of discovery, and they have then they have cited various cases to support that. The Lively motion should be denied. As fully set forth in the Wallace party's response, the Lively motion fails for multiple independent reasons, which we need not repeat. Lively blocked all discovery in this action. The reason there is no evidence of malice from Lively on the record, other than the Wallace party's well-pleaded and uncontroverted allegations, is not because such evidence does not exist. It is because Lively ensured it could never be obtained. Beginning on June 16, 2025, and prior to dismissal, the Wallace parties made multiple attempts to engage defendant in a conference pursuant to Federal Rule of Civil Procedure 26F. Lively's counsel refused, forcing the Wallace parties to seek an order requiring the parties to confer, and proposed a scheduling order. Lively opposed even that basic procedural step. And this is what bothers me, right? Is if you genuinely have a case that you believe in, then you would not be blocking all of this. If you have nothing to hide, you'd sit for a deposition. They're not comfortable, but they're not intended to be. But if the truth is on your side and the evidence is there and supports you, then, it's something you just go through. Otherwise, why bring all of this into the judicial system in the first place? Because don't forget, she's the one that filed first. Rule 54D entitles the Wallace parties to discovery. Rule 54D is not merely a vehicle for seeking fees, it's a fact-finding framework. The rule requires the court to find the facts and state its conclusions of law as provided in Rule 52A, contemplates evidentiary hearings under Rule 54D2D, and, per the Advisory Committee notes to the 1993 amendment, authorises courts to determine that discovery under Rules 26 to 37 would be useful to the parties. Judge Lyman's June 12, 2026 order in Wayfarer Studios v. Lively applies these principles directly to 47.1 fee motions. Judge Lyman's order is certainly not binding on this court, as it involves different parties, different procedural posture, different arguments, and a stipulation in which the parties agreed California law applied. Whereas here, the applicability of California law remains highly disputed. But even accepting Judge Lyman's framework arguendo, that order supports the motion for discovery here. Specifically, Judge Lyman held that Rule 54D permits courts to find the facts necessary to reach determinations both with respect to liability and amounts for fee awards. He also explained that courts may permit discovery under Rules 26 through 37, and there might be good reasons to do so where a complaint contains well-pled allegations of malice, but, as here, has been dismissed prior to the completion of discovery. Judge Lyman granted fees in the New York lawsuit because the Wayfarer parties declined to use these tools. The court closed the record in part because the Wayfarer parties have not requested discovery or a hearing. That outcome does not foreclose discovery here. Indeed, it supports it. Lively's counsel insists that leave of court is a prerequisite to any discovery under Rule 54D and characterises the advisory committee notes use of the word rare as a bar, but rare is not never. The notes contemplate that a court will determine whether discovery is warranted. They do not prohibit it. And Judge Lyman's order identifies precisely the circumstances in which discovery is appropriate, where a complaint contains well-pled allegations of malice but has been dismissed prior to the completion of discovery. That is this case. Several factors confirm this is the occasion the advisory committee contemplated. 1. The complaint was dismissed without prejudice on jurisdictional grounds, not on the merits. 2. Lively affirmatively blocked the Rule 26F process, preventing any discovery from occurring. And 3. Lively herself placed a malice issue squarely before this court by filing her request for affirmative relief in the form of her motion for costs and attorney's fees, while this case was pending on appeal, as well as, importantly, her notice of supplemental authority, emphasising that the Wallace parties must prove malice to avoid application of Section 47.1 fee shifting right based on a case of first impression under the new California statute. Lively's deposition is narrowly tailored and directly relevant. The central question is Lively's state of mind, whether she, 1, knew her allegations were false, 2, had good faith belief in the truth of her statements about respondents specifically, or 3, acted with reckless disregard of the truth, or 4, with ill will. Lively is the best person to testify about her subjective knowledge and intent regarding the Wallace parties at the time she made the challenge statements. Because malice is an inherently subjective inquiry, other evidence such as documents or third-party testimony is subordinate to Lively's own testimony about what she knew and believed when she falsely accused the Wallace parties of sexual harassment. The Wallace parties' intended examination is narrowly tailored and directly relevant to the issues Lively herself has put before this court. 1. Her knowledge of the Wallace parties' actual role, if any, at the time she made her statements. 2. Her basis, if any, for including respondents in the CRD and draft complaints. And 3. Her decision to disseminate accusations against them to the press before conducting any investigation into their conduct, notwithstanding her subsequent judicial admission in her 202 petition in Hayes County that such investigation was necessary to discern the scope of Mr. Wallace's conduct. Without this deposition, the Wallace parties are deprived of perhaps the best evidence of her malice, which Lively claims is the Wallace parties' evidentiary burden to demonstrate under Judge Lyman's ruling. She cannot have it both ways, but she'll try. The deposition is limited to a single witness and is the least burdensome discovery that could meaningfully advance the resolution of this dispute to the extent the court finds that Section 47.1 applicable, and further that the respondents have the burden imposed upon them by Lively's argument. Conclusion. The court should deny Lively's motion for fees for the reasons detailed in the Wallace parties' briefing. In the meantime, so that the record is complete, the court should order Lively's deposition and defer ruling on the fees motion until the Wallace parties have had a meaningful opportunity to develop the evidentiary record on the issue of malice. The Wallace parties also seek other relief to which they are entitled, including attorney's fees pursuant to the Federal Rules of Civil Procedure. Lively chose to seek fees and damages. She should not get to choose silence. I love it. That is so well written, and that is the absolute perfect sign-off. Again, from Charles Babcock, but we knew that as soon as I read the first sentence, I knew this was Babcock's work. So, excellent. Do we have anything more here? We've got an exhibit, so let's have a look. Okay, so we got the notice here, actually. They've included that as an exhibit. Plaintiffs Jed Wallace and Street Relations notice of videotape deposition of defendant Blake Lively. To defendant Blake Lively, etc., by her record of a council of record, as all those people. Pursuant to the Federal Rules of Civil Procedure, plaintiffs Jed Wallace and Street will take the deposition upon oral examination of defendant Blake Lively commencing on August 4th, 2026 at 10 a.m. at the offices of Lankler, Siffert and Wall. I'm not sure who that law firm is. But they're in New York, and continuing from day to day until completed. The deposition will be recorded stenographically and by videotape and audiotape before a qualified court reporter or other officer authorized by law to administer oaths and take testimony. And then that's a template order, basically, that they've included, that they want the judge to just sign, which would be to grant them their motion for an order requiring Blake Lively to give her deposition. Okay, so really interesting. Lots been happening in this case behind the scenes, and yeah, it's nice to see that they didn't sort of just kowtow and not say anything, that they brought the threats as well, especially the threats that if you do this, I'm going to send in, all my attorneys, mob heavy, and, we'll charge you all of their hourly fees, blah, 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 for doing quite a simple, motion. It's just absolutely ridiculous. And then demanding that they do not make this public when they have to file it with the judge on a public docket. The entitlement and narcissism is off the scale, but at this point, I'm sure none of us are surprised anymore. So that's what's going on. I'm sure that we will see a rapid fire response within the next 24 hours from Lively's team saying, "What? How dare you? That's not what happened. They have no right to depose us, blah, blah, blah." But I mean, honestly, Lively, wriggling out of depositions, we've seen that. That was so last year. So, yeah, we'll see what happens, and I will keep everyone updated if anything else comes in. Let me know what you think in the comments.